In a Tennessee courtroom, the case of State versus Matthew Aldridge takes a bizarre turn.
Are you Matthew Aldridge?
I'm the attorney of fact for Matthew Aldridge.
You were what?
He's not a lawyer. He doesn't have power of attorney, but he insists he can speak for Aldridge anyway.
Are you a licensed attorney?
No, I'm simply an attorney of fact.
And does that mean you have a power of attorney? What is your name?
My name?
Yes, sir. Do you have a name? Well, let me explain to you. Only an attorney at law can stand in court and represent a criminal defendant. To do so otherwise violates the criminal law statutes of the state of Tennessee and could land someone in serious trouble. You have a legal document called a power of attorney.
I do not this time.
Then you don't have any authority to act on behalf of Matthew Aldridge in this court.
Why don't we court just let me file this document?
Show it to the bailiff and he'll show it to me.
The judge plays along, but continues to poke holes in this mystery man's argument.
All right, this is in the state of Tennessee of Cheatham County and Chancery Court, which is filed in the wrong court because this is circuit court. You just be quiet. You need to listen to me instead of talking. This is a challenge to the standing. The Supreme Court of the United States has stated that no corporation has standing anything to man. Latin phrases, dissimilar things ought not to be joined by a definition of Black's Law Dictionary.
This is straight from the Sovereign Citizen Playbook. Latin phrases, random case law, and demands that the court prove its standing. None of it works.
And then this was signed by Matthew O'Neill Aldridge. Is that your signature?
That's the respondent and error signature.
Well, I find that Matthew Neil Aldridge has failed to appear, and as a result, you have no standing. What I know what you're trying to do is to try to use the sovereign citizen approach to this situation, and I'm simply telling you what you're attempting to do has no legal effect. You cannot challenge the jurisdiction of this court by simply filing some legal mumbo jumbo having to do with civil litigation. But I don't know who you are, and I don't think you have any authority if you are not Matthew Lynn Aldridge to appear before this court. And you're wasting valuable time to all of these other citizens who are here today. So when I'm talking, you stop talking. General, we're going to need to set a trial date to Matthew Aldridge, and the individual standing before me must not be uttered. Then we will set a July 15th trial date.
The trial gets reset, Aldridge is warned to show up, and the filings are tossed in the trash. But while this man tried to sneak into court as someone else's lawyer, the next defendant blows things up from inside his own case. This was a probable cause hearing for first-degree retail fraud. The defendant, Timothy Dansby, had two lawyers. All he had to do was say whether he wanted them or not.
Listen here, if you don't answer the question, I'm gonna release the lawyers.
The judge pushed harder, and what should have been a routine question turned into a fight over rights, discovery, and whether the court itself was even legitimate.
Mr. Dansby, can you please state your full name for the record?
All right, Mr. Dansby, we're back. Do you mind having Ms. Miller stand in for Mr. Gonick for today's hearing?
I still reserve my right to mention all the previous hearings, but
Okay, you know what? I'm not gonna play the game. It's a yes or no question.
all right.
Okay, do you want to adjourn it and see who it is? You have a right to have the counsel of record present if you want. Okay, so you don't want a lawyer, sir? I'll release him if you don't want one. Nobody's gonna force you to have a lawyer to help you. If you want to do it all yourself, do it. Do you want me to release the lawyers?
Bank firm soon right up.
Do you want a lawyer? Yes or no? It's a real easy question, sir. It don't take all day.
She's giving him one last chance to say yes or no. But our guy, he's more interested in delivering a TED Talk on representation.
Listen here, if you don't answer the question, I'm gonna release the lawyers because you've been complaining the whole time about, I didn't ask for no state attorney. I don't want to, I don't know what it, whatever you gonna do. Okay, so you don't want them? Is that what you're telling me? Do you want them, yes or no?
I still ain't got my discovery, so
Do you want a lawyer?
I'm still on the same thing I think.
I don't even know what that is. Whatever your claim is, I don't know. Okay, let's release the lawyers.
The lawyers are gone, her patience is gone, and the hearing is collapsing.
Now, you're not getting another one. I'm just telling you.
I reserve the right to ensure everybody on the legitimacy of the court.
What, you can reserve what you want. I don't mind.
Findings of the court and the legitimacy of the court as far as the defense argument practice.
Sir, whatever you want to do. Since you don't want a lawyer, I can't by law give you one.
Lord have you given me the things that I need.
Okay, sir, nobody can give you anything. but a piece of paper. They can give you that. They could give you the police report. They cannot give you the videos. There's no way for you to watch them.
He ordered at the law library clerk to have a clerk or somebody to present the information for me to see the video.
I don't know anything about your law library. These video files, they're files. They come on a computer.
So the hearing ends with no lawyers, a court order to hand over discovery he can't even watch, and a defendant still convinced he's preserved his rights. One simple question turned into 15 minutes of chaos. And if you thought that was ridiculous, wait until you see the guy who tried to bill the court $1,400 for his time.
Good morning, sir. Would you state your name, please?
My name is Randall Timothy Crane.
Good morning, Mr. Crane.
Charged with obstructing an officer during a traffic stop in Taylor, Michigan, the defendant, Randall Crane, had just lost his lawyer after disagreeing on how the law actually worked.
Had a breakdown in communications. I don't believe I can go forward representing them. We do not support the same theory of law.
All Crane had to do was agree to return on July 16th, but instead he claimed not to understand and turned the hearing into an argument over jurisdiction.
Mr. Crane, sir, do you wish to have a court-appointed attorney, or are you going to represent yourself at this time?
I would like to have assistance.
Okay, but at this time, we do not have other counsel. What I am going to do is what we call an arraignment. All arraignment, sir, is just a formal reading of the charges that are lodged against you. That's all it is, and I explained that the rights that you have.
Well, I understand my rights.
Hold on, just a minute. I want to make sure I have the complete file. You are charged on the complaint that you obstructed the officer from performing his lawful duties. He claims he observed you operating electronic device. You're on a personal bond. It's your word that you're going to come back on that July 16th date. Understood, sir?
No, I do not understand.
Pardon me, sir?
No, I do not understand.
Well, I'll explain it again.
The judge repeats the bond conditions slowly, but Crane keeps cutting him off, insisting he doesn't understand.
That's when they discuss the merits of the case. And right now, I've released you on a personal bond. It's your word that you're coming back on that date.
Yes, Your Honor, I understand that part. I don't understand the jurisdiction that the court has over me.
Sir, you're going to be able to discuss that at a later date. This was just to advise you of the charges.
Well, I would also like to advise the court. Every day that I am in court, I require $1,400, and I will be charging the court $1,400.
Sir, you can do as you see fit on that count. I'm just apprising you of your court dates. And with that, you're free to leave the meeting, sir. Thank you.
After demonstrating a masterclass in handling sovereign citizens, the judge ends the call, leaving Crane with no leverage, no paycheck, and a case still moving forward.
Officers initiated a traffic stop in Harris County, Texas for a vehicle having a fictitious plate bearing the word traveler on it.
Traveler?
Pulled over with a traveler plate in Harris County, Texas, this sovereign citizen and his lawyer make one last desperate attempt to save his bond.
During the stop, the defendant refused to provide ID or insurance information, stating, "I do not consent to this." Officer attempted to remove the defendant from the vehicle, and defendant actively resisted by pulling his arm away from deputies until he was detained.
His lawyer appeals to pity, claiming he only pulled away because he was scared of multiple officers tugging at him.
In this particular situation, he didn't interfere with anything in terms of his own arrest. If it was a resisting or something to that effect,
They're just trying to get him out of the car.
I don't disagree.
It's classic sovereign case where got the license plate, traveling by right is what I think how they term it.
In this situation, Judge, and the reason I'm employing upon the court is, even from what Madam Prosecutor has seen on the video, they're pulling and tugging at his arm, which put my client in some fear. It was more than one officer.
But he still has a duty. If they're asking you to come out, they can lawfully do that. Officers will literally destroy your car to get you out.
The judge's patience is wearing thin. Daly's already missed court more than once.
The problem is, Mr. Daly, we revoke your bond and you've continually failed to appear. It shows me that you just refuse to accept authority.
Is I asked the court to take into consideration, we have a black male works every day who, and I hate to put that on the court, but I do in this particular climate. From what I can see and what I hear out here, because they are unfamiliar with the court system in this particular climate and seeing what they see on TV and everything that has occurred, you don't know what the proper steps are. I'm not saying that what he did was right or wrong. However, I'm employing upon the court to take into a little bit of consideration from his perspective, from what I've known from this particular case. Sometimes they just don't know. So I'm asking to reinstate his PR bond. I run a tight ship. I believe I can reach him in getting him to court and resolving this matter.
I'll buy it.
Yes, sir.
Okay.
Thank you, Judge.
I'm not going to do this again, though. If you flake on us again, that's 3 times. It's out. I'm not going to do it again. Do you understand, Mr. Daly? Do not drive. Do you understand? Heed this warning.
Daly's bond is reinstated, but on razor-thin ice. The judge leaves him with this last piece of advice.
For future reference, when you get into a pissing match with someone with the power of arrest, you are nearly always going to lose. And as a young black man in today's society, you got to be extra special careful because things can go really wrong really quick. And there's evidence of that over and over and over.